Good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and along with my associate Arta Goker, we represent Mr. and Mrs. Sammons. I'd like to reserve 5 minutes, please. This is a two-issue appeal. The first issue concerns interpretation of Rule 1.260A1, and the second issue concerns excusable neglect. And just to clarify the appellate relief that we're asking for, if we prevail on issue 1, that would resurrect the wife's case, and if we prevail on issue 2, that would resurrect both the husband's and the wife's case. So with the interpretive question about Rule 1.260A1, we start with the rule's plain language, and it says, unless the motion for substitution is made within 90 days after the death is suggested, the action shall be dismissed as to the deceased party. Now, it clearly does not concern the dismissal of a case as to a living party. So there's a little bit of a
Except for the living party's case is derivative of the deceased party's case, which in this case, he died of things other than this incident, which makes this a little confusing and interesting.
It certainly is a little squirrely. And that gets us into the split between the DCAs. There's 3 cases that seem to govern this issue. Taylor against Orlando Clinic and Randall against Walt Disney World Company, both of which are out of the 5th District. And then there's AC&S Incorporated against Red out of the 3rd District. And the factual situations in Taylor and Red involved decedents who died of the injury that they were asserting. So those causes of actions would have abated into a wrongful death action.
Thinking that through, does that really matter in this case? Because the action wasn't taken in time to perfect his case. So when his case went away by operational law, how can hers survive?
Well, that has to do with whether they prevailed due to a procedural defect or actually on the merits. And there's a whole body of Florida Supreme Court cases saying it's sort of it's just a weird area of law where it's simultaneously independent but also derivative of the decedent's action. So
because his case was procedurally defeated, not a determination on the merit. There was no factual determination that he shouldn't proceed. Her case can survive.
Precisely. That's our position, and we think that's borne out through the Taylor case and the Randall case. And one of the key differences there is Randall actually involves the exact factual situation we have here, which is the cause of death. It's not established that it was because of the incident about which he was suing for a personal injury. So there you have this, if it was the same injury that caused the death, then you'd have abatement into the wrongful death whole scheme. But because it's potentially different, you can't do that. And that's why the 5th District doubled down on its decision in Taylor, saying, no, we decided this in Taylor. We know what the 3rd District did in Red. We disagree with that. Here are our reasons. And so that's what we're really hanging our hat on the interpretive question under issue 1. And like I said, it's all about whether it's on the merits and it was factually determined, and that's not happened here. So that's why we should win. And
I have a vague recollection of cases in which spouses, there's an injury, some event occurs, spouses divorce. Let's assume for the sake of argument, husband is the one who's injured and the wife's claim is derivative. They divorce, husband decides he doesn't want to pursue the claim. My recollection is the wife would still have a viable claim for what she lost, independent of his claim.
That's correct. The names of some of those cases are escaping me, but one of them that's immediately coming to mind is the Busby case, which is a 1955 Florida Supreme Court decision. And there, I think it was the husband who was actually pursuing the consortium claim, and the Supreme Court said, well, it doesn't matter that the wife's not involved in this case. The husband can go forward with his consortium cause of action.
Had a claim for losses.
Precisely.
As a result of the other spouse's inavailability for whatever, whether it's income producing or consortium generally.
Precisely. And there's a hypothetical that helped me kind of sort through this issue. And here, the husband can't proceed with his case because he's out of luck with the statute of limitations. But imagine that the Florida legislature said, you know what, we don't like the 2-year statute of limitations. It's now 4 years for medical malpractice. Could the husband refile, and would the wife still be able to pursue her consortium claim? And I think clearly the answer for the husband is yes. There's been no adjudication on the merits as to his claim, It's just he's procedurally knocked out because he didn't comply with this this rule, and then he because of that he can't satisfy the statute of limitations. So that's the first issue. The second issue has to do with excusable neglect itself. And here there's two paths that we're proceeding down. One is like two ways that you can look at this. If the averments in in the lawyer's affidavit were true, they established excusable neglect. And there's a series of cases that we've relied on to establish that. And those are, for example, Mims, Paul, and Somero. And then there's a series of cases that the other side has relied on. Most of those are just factually distinguishable, where they're dealing with a lawyer who screwed up or just was a little bit lazy. The only case that's kind of close that maybe deserves a little bit more of your attention is this Bowers against Alez case, or Ale. That involved medical issues, so that seems kind of close. But the medical issues that they were complaining about had to do with a period of time that had previously occurred. And so that time had previously occurred, they got the extension, and then they're saying, well, we still didn't comply with the deadline. And the 4th District in that case said, well, you know, there's just a disconnect there. Your medical issues didn't relate to your failure to comply with the deadline. So we think we substantively prevail on the averments in the affidavit. And then we think we also procedurally prevail because there should have been an evidentiary hearing on this.
Did your client ask for an evidentiary hearing?
She did not.
Did your client instead basically leave it to the court to resolve on the record and the affidavit? It appears the answer is yes, because they argued the merits of whether she was truthful, whether Ms. Sammons was, whether the attorney was truthful or not truthful. So it seemed like they were tossing it into the judge's lap to resolve based on what the court had.
I'm sorry, I spoke over you. They were going back and forth about what was really going on, but there were some things that were missed out on by not having an evidentiary hearing that I pointed out in my reply brief. So there was no discovery.
There was no additional request for an evidentiary hearing?
That's definitely correct. She didn't do it at the hearing. She didn't file a motion for a hearing. But on the other hand, these are issues that weren't raised in the answer brief. You can raise it yourself, but you don't have to.
Thank you, Mr. Burns.
Yeah, I know. Well, right. But there are some things that were missed out with the evidentiary hearing. Like, it would have been nice to have a little bit of discovery. It would have been nice for the judge to consider some medical literature about this. Would have been nice to take some testimony, actual testimony from Ms. Banash rather than a little back and forth. Maybe hear something from her doctor, and maybe hear from these attorneys and paralegals who were apparently assisting her. So you have discretion to well, I don't want to get it. You'll figure out what to do with how you're going to review that. But our point is, evidentiary hearing would be nice.
Part of the argument you just made suggests there could be such testimony to be supportive, but there's an equal thought that there may not have been a request for an evidentiary hearing because maybe there is no one that would support her theory.
Just unknowable. We don't know one way or the other. So that's our appeal, unless you have further questions.
Very good. Thank you, Mr. Burns.
Thank you.
If I could respond, may it please the court. Isaac Ruiz-Cruz on behalf of the appellees. I'd like to take up the second issue first, because I think if there is excusable neglect that's found, well, then that would suddenly resurrect both of the claims, and there's really no need to reach the first issue, and that is the wife's claim. This is distinguishable from, well, even the Mims case that I previously argued to the court on the other side. And that is because here there was a consideration of evidence by the trial court. This is not an instance in which the counsel was precluded from presenting evidence. It's not an instance where counsel just made a bunch of unsworn statements. It's also an instance in which the court exercised its discretion, which is different than the Paul versus Wells Fargo case, which Judge Morris and Judge Silverman, you were both on that panel, in which the court found that the court had found that it had no discretion to consider evidence with respect to illness or other infirmities that counsel might have had. So this is a situation which we're squarely within the abuse of discretion standard of review. And there's countless cases that find that whether you're under 1.260 or under 1.540 on excusable neglect, if a trial court is presented with evidence of excusable neglect, what the court decides to do with that in granting or denying the motion is going to be an abuse of discretion standard of appellate review. If it's granted, then it's actually a higher standard of appellate review, gross abuse of discretion versus just an abuse of discretion. And the point is that each of the cases that we could find in Florida, everyone that dealt with the infirmity or illness of an attorney is distinguishable from the facts here. And the one that is similar was also a case in which the appellate court found that there was no excusable neglect. So if you look at, to go through all of the cases, Lineberger was a manic depressive psychosis which resulted in a hospitalization in a mental hospital. The Jason Rading case dealt with an illness that had confinement in a hospital. The Rosenblatt versus Rosenblatt case, shot and hospitalized during the time to respond to the service of process. The American Network Transport case, hospitalized with kidney stones. The recurring theme is that in each of these cases, counsel was hospitalized, preventing counsel from responding because they were in fact in a hospital. The Paul case was the incapacitation of the plaintiff, and that was an elderly woman in responding to a mortgage foreclosure action. And it was actually spelled out in the decision that there was an incapacity. Now, in Bowers versus Alice, which is the fourth DCA case that we think is most similar to the facts here, there was a motion to set aside a default judgment, again, claiming medical emergencies. And the court cited to Paul that illness can be excusable neglect under circumstances clearly interfering with the party's ability to take action in the court. And there was no allegations that the medical issues kept him hospitalized or incapable of communicating with the court during that time. And the court found that that was not excusable neglect. Here, what was presented was an affidavit. And the affidavit of Ms. Banache was presented at the hearing. And what was filed, if the court looks on December 16, 2016, which was the day of the hearing, was a 3-page affidavit that was missing the 3rd page. It had no execution. 4 days later, on December 20th, she files the affidavit again, and this time includes the execution page. What the affidavit says is that in late July or August 2016, she became aware of having difficulty with her memory, that she was diagnosed with hypothyroidism, that she had brain fog and memory lapses. And there's an attached doctor's note, and the note says, quote, she has been having cognitive changes. The judge at the hearing went through these statements that were in the affidavit and indicated that there had been actions taken by counsel during the case. During this period of memory fog, the lapses in mental function that are averred in the affidavit, counsel's filings with the court to set up the estate, getting the estate set up, filing notices of unavailability with the trial court indicating that she's unavailable. When she was questioned about that notice of unavailability by Judge Mansfield, counsel responded that she's going to Jerry Spence's trial lawyer college in Wyoming. And the court determined, well, if you're going to trial lawyer college, clearly you're capable and competent to what you're doing in court. And there's also an email that was admitted at the hearing. And by admitted, I mean that counsel admitted to having sent the email, not that it was actually admitted into evidence. It was presented to the court, and the court retained it, but it was not formally entered into evidence. And that email was from August 9th. There was a letter sent by defense counsel to the court because there's an administrative proceeding in Pasco County that permits you to, if there's no opposition to a motion filed, request that the court rule on the motion without having a hearing. So the letter was sent, and counsel, plaintiff's counsel, immediately responded that day with an email indicating that I'm out of town, I intend to file a response. There was an email, or excuse me, an error with the bond, and that's why we required more time. Please set this for hearing. And she admitted having sent that. So the court took into account the actions of counsel in responding with these emails, filing notices of unavailability, setting up the estate, taking actions during the course of this case, and took into account the sworn proof, that is, the statements that were made in the affidavit, and exercised his discretion and determined that this was not excusable neglect. So we would suggest to the court that this is an appropriate exercise of the discretion of the trial court in not determining that there was excusable neglect. Now, the Steinhardt case is really the only 1.260 case that deals with directly this issue of an evidentiary hearing not being given. And that's Steinhardt versus Intercondominium out of the 4th DCA. The other cases involving evidentiary hearings are all under Rule 1.540. And the important distinction in Steinhardt is that there was a specific request for an evidentiary hearing on the motion. There is no such specific request in this case. And quite frankly, there was essentially an evidentiary hearing. There was sworn proof that was presented. Every one of the 1.540 cases on this issue deal with the fact that counsel presented unsworn proof but didn't have an opportunity to present sworn proof. Here, sworn proof was actually presented. The averments that she wanted to get out, that is, that she had some brain fog or had some sort of memory issues, she was able to put that before the court and to do it by way of sworn proof. It simply wasn't, when the court considered everything, enough for the court to consider that this was excusable neglect. That leads us to the first issue, which is this issue involving the wife's loss of consortium claim. If it weren't for the decision in the AC&S case, I think it would be very clear under Florida law that the wife's loss of consortium claim was not defeated by virtue of the fact that the husband's claim was dismissed because it was not on the merits. We know clearly when there's a dismissal for lapse under 1.260 that it would be without prejudice, but for the fact that here the statute of limitations had run, which turned it into a prejudicial dismissal. Now, the difference here, of course, we have the AC&S case, and the AC&S case is saying, the 3rd DCA in distinction to the 5th DCA, is saying that because this is a derivative claim, the wife's claim is derivative of the husband's claim, it abates on his passing. And so there isn't a loss of consortium claim that survives his death. The court there considered the arguments in Busby, that is, that if there's a release or if there's some sort of a consent agreement or consent judgment entered into place, that it still would survive. Now, those aren't particularly satisfying arguments. I teach remedies. It's dissatisfying to have a situation where a wife's left with no remedy. And what's especially dissatisfying here is that it doesn't come into a wrongful death claim because the husband didn't die as a result of the amputations, or at least there's been no allegations to date that that's the case. So the wife wouldn't even recover as a beneficiary of the estate for her pain and suffering as a result of the injuries to him. So it's a dissatisfactory result, but we think it is a result under the AC&S case, and we're asking that the court follow the well-reasoned opinion of the 3rd DCA there versus the 5th DCA's opinions in Randall, which state that even though it's a derivative claim, it can be and is separate and distinct, and what separate and distinct means is that it can continue to exist even after the husband's death. The 3rd DCA says separate and distinct doesn't mean that. Separate and distinct means that it can just be filed separately. But it's still derivative on the husband's claim, and if the husband's claim fails, then the wife's claim fails as well.
Does the 3rd DCA's analysis take into account the scenario that I brought up with opposing counsel where a spouse simply does not want to go forward, or ex-spouse doesn't want to go forward with a case, but the consortium claims is still permitted to go forward?
It cited that line of cases and still found there's not a whole lot of explanation on that particular page of the opinion, but they do cite to that line of cases, and they also cite to the release and consent judgment that I'm discussing, that I previously discussed with the court. And it's not a very satisfactory response, but the court finds that separate and distinct doesn't mean that if one action fails, then the other can continue to survive. It just simply means they can be filed separately. And for those reasons, we would ask that the court affirm on both grounds the trial court's dismissal of the actions. Thank you.
Very good. Thank you, Mr. Ruiz.
I just have 3 points to make. We agree about the standard of review for the excusable neglect issue, but I disagree with this interpretation of the cases that hospitalization is the bare minimum that's required to, or the minimum, the floor that you have to establish to have to show to establish excusable neglect. I think that's inconsistent with Florida's longstanding policy to determine disputes on the merits, and we disagree with that. There's an argument about, like, well, you effectively got an evidentiary hearing. Setting aside the standard of review you apply to that because there was no request for an evidentiary hearing, I think they could not establish harmless error here. It would be their burden to establish harmless error beyond a reasonable doubt. And there are things that were missing that would have happened had there been an evidentiary hearing, and I addressed those both in my initial argument here and in my reply brief. That's the discovery, the review of medical literature, and taking testimony from Mrs. Benash, her doctor, and the other attorneys and paralegals. And then the final point has to do with Rule 1.260. I think you have the materials you need to decide that. It's just read these 3 cases from the 5th District and the 3rd District. We agree largely on what the facts are, and then you'll tell us what the outcome is. So with that, we'd ask that you vacate the judgment and remand for further proceedings.
Very good.
Thank you.
Thank you both. We will take a 10-minute recess and then finish with the last 2 cases on the docket.